Ladies and gentlemen, welcome to another episode of Legally Speaking. I'm your host, Oves Anwar. Lawyers are in the business of dispute resolution. At least that's what we try to portray. But the traditional dispute resolution mechanisms, the ones that we're most associated with, the court system, leaves much to be desired. They are costly and they often take far too long to resolve a dispute. But alternatives exist, and the entire field of alternative dispute resolution is dedicated to unburdening the courts, as well as finding cheaper and faster options for litigants or for people who have disputes. A growing field within ADR is mediation. And to discuss this, I am joined by Dr. Nudrat Piracha, who is CEO of the International Center for Appropriate Dispute Resolution and Prevention. Thank you so much for joining me. Nudrat, welcome to the show. Thank you so much for joining us.
Thank you so much. My pleasure.
Nudrat, I wanted to start off with, ADR, given its ever increasing, I think, importance in Pakistan. Where do you feel, what are some of the basics of ADR that we need to understand in the Pakistani context specifically, in your view?
So, Pakistan, I think the most fundamental thing is that it has already been there.
Mm-hmm.
So, ADR is part of our culture, it is part of the system.
Okay.
So, it's not something new and it's not something that we are importing from the West. So, that I think is fundamental to understand.
I see.
Right? And in terms of systems, I think that is something not many people know. And what is mediation, what is arbitration, there are many forms of ADR. But these forms are not known to people by those names. So there is a need for building capacity, not only just with the judges, the lawyers, the users of the system.
Mm-hmm.
They need to know that this is an option that is out there,
Mm-hmm.
and it is an effective option. So that, I think, knowledge is not there at the moment. Very few people know.
Absolutely. And when we speak of ADR, but more specifically mediation, what do we mean? How is mediation, say, different from other forms of ADR? Conciliation ho gaya. I mean, you got things like arbitration itself, all of these things. Mediation specifically, I know that there's a lot of effort being put in Pakistan to formalize this as a mechanism of dispute resolution.
Right.
So could you define, perhaps set the parameters, what exactly these are?
So in mediation, what is actually happening is there is a facilitator, and that facilitator is trying to facilitate a resolution between the parties.
Okay, so this is not a judge.
He's not a judge.
Okay.
He's trying to just facilitate keeping the parties on the table and trying to facilitate some kind of a resolution. That resolution is coming from the parties.
I see.
So there is a lot of autonomy in the system. So the parties are going to come up with the solution that best suits their interests.
I see.
In adjudication or litigation, basically it's an adversarial system.
Mm-hmm.
So the judge will decide who's right and who's wrong. The mediator is not deciding right and wrong. The mediator is simply trying to see if there is something between these parties that can lead to some kind of a resolution that is more permanent.
I see.
Right? In arbitration, again, the arbitrator selected by the parties is going to decide.
Mm-hmm.
Now, you might not be happy with that decision, I might not be happy with that decision, but you're stuck. Then, when there is no ownership for that decision, you'll keep seeing appeals after appeals.
Yeah.
So when you come up with the solution that is yours, there is instances in the West, very few instances where people are going to go back and challenge those settlement agreements, because it's a solution given by themselves.
Absolutely.
Right?
Absolutely.
So that's where I think mediation is very different. And one more thing that I have seen, and I think is the beauty of mediations, that is, out of all the dispute resolution systems, mediation is the only system that recognizes that you're dealing with humans.
Actually, wow.
Human emotions have no place in any adversarial system, in arbitrations, these adjudications. In mediations, you're trying to get to the bottom of the problem. What are the underlying concerns? If you are stuck on a position, what's making you so inflexible about moving away from that position?
I see.
And if you look at companies, let's say there's a huge dispute and there is a company involved, come to think about it, it's not the companies that fight. It's the people behind those companies who are fighting. It could be personality clashes, it could be egos, it could be so many things.
Absolutely, that's often the case when you see, in courts.
So the people fight, yet no dispute resolution system caters for the fact that you're actually dealing with humans.
Yeah.
So my first interaction with this problem was when we were working on the Binder case.
Oh.
In ICADRP, it was a $700 million case.
Wow.
And Pakistan was facing a huge claim against them, against it. And there was one person that the tribunal asked that, look, one party was saying X, the other party was saying Y. Why did you not just go and take a look whether that's the case or not? And this person said that the rep of the other side, if I did that, I would have to sit in the same car with him for 3 hours. And I could not put myself to do that.
Oh, wow.
And you are here having millions of dollars of claim just because these two people can't get along with each other.
My God. Yeah.
Right? So humans are important, of course.
Of course. Yeah.
It's the emotions and it's the people who are the part of the problem. Yet no dispute resolution system caters for that element that you're dealing with humans.
No, I think that's a really important point. Also, I think brings me to the fact that sometimes as lawyers we live in this bubble where we think everything should be looked at from a legal lens, right? And my understanding is that in mediation, the mediator does not even have to be a lawyer or legally trained.
Yes.
And so how does that, maybe impact how mediation is done if, you don't have a legally minded individual involved or somebody who has this type of background?
Right. So, as I was saying earlier, in order to know the law, you of course are working with a process. When you know the law, you know there's a process, and then you know what is right and what is wrong. Right? So that's the tool that you will need to determine who's right and who's wrong. Yeah. That's the utility of the law.
That's the yardstick that you have.
It's coming from the law. But when in mediation, that is not your mandate. You are not sitting there to decide who's right and who's wrong.
According to the metric of the law.
That's right.
Okay.
Right. So you are not going to validate any party during the mediation that, I think what you did was wrong. You'll never do that.
I see.
So any person, even with the non-legal background, all that you need to know is the process. If you have these parties who've lived with this dispute for many years perhaps, they don't even want to talk to each other. How do you keep these parties on the table? How do you help them see through a different perspective? And then slowly bring them towards a resolution, and if possible towards a closure. Absolutely. That is the mediator's skill. And you don't need to be a lawyer. And I myself, I feel, because for 22 years I've been working in arbitrations, for me it was a major mental shift. I think you have to put that hat, that arbitrator hat, that counsel hat away. And you really need to understand, again, the dynamics that you are dealing, as I say, with people, with actual human beings. As a lawyer, I don't care how you feel.
Absolutely. And as a lawyer who doesn't have a lot of experience in this area, I think it's really fascinating that you don't get the satisfaction of you're right, you're wrong, you're innocent, you're guilty out of this right. But you get the satisfaction of closure of the actual thing. Both parties actually technically satisfied in this regard, right?
Yes. Because I think it is the only process that really can bring closure, and it can preserve those relationships.
Wonderful.
So we are working with the Islamabad High Court and doing mediations virtually on a daily basis. And it's beautiful, really. I mean, these people would be stuck in the courts maybe sometimes for 15 years, 20 years. Imagine you have a dispute with your brother. You're living with that dispute for 20 years.
No, absolutely.
Right? And then there is this possibility, small window, that today you can close that dispute within 3 hours perhaps. Because most of the mediations don't take more than 3 hours.
Really? Wow. Yes. As opposed to years in litigation.
In litigation, yes.
Wow, that is.
And it's a permanent closure. Because once parties walk away, many of these people are walking away with those relationships repaired, those gaps bridged, and no hard feelings.
Absolutely.
You don't have to live with that dispute anymore.
Nudrat, I wanted to ask you, this element of that satisfaction where one party is right and they get to laud it over the other. Is this not part of the culture almost in Pakistan, and why we're such a litigious society, if you will, where we want to gain that win over someone else, that one-upmanship, what we call, and don't you feel that is part of the thing? Do you think that Pakistan culturally is ripe for mediation as a solution to many of the disputes that can be resolved here?
I definitely think so. I think this is a misconception that people in Pakistan are litigious. And you look at US, people are even fighting over the coffee was too hot.
That's very
so
true.
There are, of
That's
course,
very
that is a society where I feel people would sue you for the smallest thing.
You slip in your department store and it's a lawsuit right there.
Yes. You look at some of the lawsuits and you're wondering, it really did cross someone's mind. In Pakistan, I think that is one of the perceptions that I came across early on when we were trying to push mediations in Pakistan. But I think the fact is, many of these cases, there are of course cases which will never be mediated. Not every case is suitable for mediation. But in the first experience of Pakistan, where in Punjab they were trying to push these mediation courts, mediation centers in Punjab, about 40,000 cases went for mediation, were sent by the judges to mediation. And the rate of success in those cases was, I'm told, about 70%.
Wow. I see.
Now, one of the exercises that someone informally shared at the World Bank that they did for Pakistan was that out of that experience, which were the cases that were settled, right? And they created those categories, and then looking at the backlog in Pakistan, that if you were to implement that data to Pakistan now, the existing data, and according to them, again, about 70% cases that are pending in Pakistan at the moment are suitable for mediation.
Really? Wow.
Based on that past experience. So I don't think we are a litigious society as such. I feel culturally, once you have tried every other option, that is when you will come to court. Right? So many of these people who are coming to court have had multiple experiences where they've tried to settle it somehow, but it didn't work out, and that's why they're in court.
I see.
So in Pakistan, it, I feel, is relatively very easy because one, the religion supports it. Islam has a very strong push for mediation, and second, I feel culturally, the society wants to settle. They want to keep the relationships. But yes, there will be people who would tell you that I want my day in court.
Yeah.
Those cases are not fit for mediation. But most of the cases are not those, where people are just wanting to push someone through that humiliation and that system.
Yeah. Okay.
Many a times, when you start speaking to these parties, you realize there are considerations which are more important. Right? Some of the cases that we settled for the Christian community, those cases were settled again in 2 sessions of about 3 hours. So in 6 hours, we were able to settle those disputes. And they were essentially brothers or family members, and relationships were more important at the end of the day than that satisfaction that I was right.
Yeah.
So they settled.
No, absolutely. And I think when we look at it from, say, a society perspective, this is more restorative, right? It is healing society.
That's right.
As opposed to having a judgment which says one is right, one is wrong, and then that can fracture more of relationships between family members or relationships. So I think it's a very, very strong tool in that regard. Nudrat, I wanted to ask you, you had mentioned that there's certain cases that aren't suitable for mediation. Could you elaborate a little more on that? I know there's some individuals who just want to go to court, get their day in court, and maybe they trust that system a little more.
Right.
But there must be some categories perhaps of cases which are not so suited to mediation.
So Here again, I think Pakistan is an exception, and Muslim countries are an exception. In the West, they think criminal cases are such that cannot be sent to mediation.
Okay, yeah, absolutely.
But we in Pakistan, even there, we have this mandate which says Sulah is better.
Absolutely.
Right, and to forgive is better. Eye for an eye, but to forgive is better.
Yeah.
So even for criminal cases in Pakistan, it can work. What is not suitable, I will give you one example. Some of the cases that were sent to us were cases which were ex parte. Now, if the might of the state and the power of the court was not able to bring a party to the court, how can a mediator bring
Who
that
has
party?
no legal powers like
Very
that.
soft power.
Very soft powers, yeah.
How can that mediator bring those people to the table?
Yeah.
Right? So that is one example of a case that is unsuited.
So you need voluntary submission by all parties
That's
to the process. Okay.
To begin with, it again varies culture to culture. But in some of the jurisdictions, for instance, let's take Italy, they said mandatory mediation for 3 hours.
Okay, wow.
Right? In those 3 hours, the center then had that opportunity to at least educate the parties. That if they are going to refuse mediation, do they really understand what they are refusing? Right? So mandatory mediation is one way to go. One can ask the parties that they need to have at least, I would think, a session.
I see.
3 hours, 4 hours. Even in California, you have these people who are sent to this, they have this multi-door policy in Washington DC. And in California, again, the court will send you to any form of ADR. You can select which form of ADR.
It's court mandated in that
Court
sense?
mandated. So once those parties are in the room and let's say they say mediation, you will have a mediator who will offer his time for free for 3 hours.
I see.
After that, if the parties feel this is something useful, they might contact that mediator and pay his hourly rate if it needs to be continued. But even there, it is a session that is mandatory.
To explore at least the possibility
Explore at
and
least.
allow them to get a flavor. It's like a free sample,
Yes.
if you will. Yes.
Because right now, people, if they refuse mediation, people are afraid of what they don't know. So if you are sending them to the mediation center, they have no idea what they are going to be exposed to.
Yeah.
Then the first sentiment is fear. And the second, I feel, sentiment is if you do not have that buy-in, then it's, I think, human nature that if I do something which is not with your permission, you'll feel violated. So sometimes I give the example that let's say we are sitting in a plane and I reach out and I open the window without your permission.
Yeah, absolutely.
Right? You just feel frustrated. Why did she do that? She could have just asked. I could have done it for her, or she could have just asked for my permission.
Absolutely.
Rather than bypassing me and just lifting the lid herself. I think human nature is the same. If you force something that you need to go to mediations, the first thing that you will get is a reaction.
Negative reaction.
We won't do it. Right? So I say maybe 3 hours, 4 hours. Mandate that, but don't try to mandate the process. That has to be voluntary.
I see. Well, that's a really interesting take on I think the psychology behind getting into mediation and what makes it work or not. In Pakistan, we've had the ADR Act now for almost a decade. What, in your opinion, are some of the issues on the ground that prevent it from actually getting implemented, or some of the challenges that we're facing in its implementation?
So many of our laws, I feel, and I might be wrong, this is my observation, I feel many of the EDR laws in Pakistan or EDR provisions, I'll talk about them first. Many of the funders would have a requirement that put this in the law, this is good for you, and there was no implementation on that. Right? No one really understood how to implement that. So you have now many laws, and I'm drafting the regulations for public-private partnership authority.
Okay, wow.
They have the act which says mediation can be facilitated by the authority, but there's nothing to back that up. How do you, in practice, how do you really do that?
Yeah, that's true.
Similarly, if you look at even the 1940 Arbitration Act, it said that the court could they could give you the rules for the 1940 Act. Was never done. Right. Similarly, in 1940 Act, the ADR Act 2017, there was no implementation to begin with. Many of the judges did not even know about that when we started speaking to them that this is actually an act as well that can be considered. So if you do not put the systems in place, right, the implementation, even well-intentioned people, they can't implement it. So I think the change in especially the Islamabad High Court with Hassan Aurangzeb Sahab, Justice Hassan Aurangzeb, then there is Justice Ijaz Ishaq, then others in the Islamabad High Court, they started pushing for mediations to be properly introduced in the system in an institutionalized way.
I see.
So that's where some of the framework started emerging then. Now there was, in those rules, there was this provision that you could either go to the court or you could, for mediations, go to these designated centers. But again, there were no rules as to how would these centers be designated. Then there were provisions about designated mediators.
But it's so strange. Rules are supposed to be easier to pass, right? They're supposed to be that it's just government officials, civil servants who sign off on a thing and get it passed. Whereas legislation is the challenge, right? Where you get legislators who have to vote in a majority to get this thing passed. So why do you think that's? Is it a cultural, a civil society or civil service culture, or is it just that we like pushing the challenge down the road?
I think my answer would be twofold. One, I think, is a capacity issue.
Okay.
So many of these people who want to do it do not know realistically how.
I see.
And if you make things so expensive that you can do that only once the funder comes in, right, and you have some kind of funding to finance that. So there was genuinely a capacity issue that how can you really implement this system, right?
Yeah.
Second, I think, is an issue that not just Pakistan, many of the countries have had. That is how to bring in a new system, right? So there are usually two approaches. One is a top-down approach, and the other is a bottom-up approach. So the top-down approach would be you have a champion judge, and that champion judge would then work for that cause.
I see.
Like Islamabad High Court, you had champion judges. Mansoor Ali Shah Sahab, champion judge. He pushed it in Punjab, he was pushing it in Islamabad as well. So champion judges and these people in the law ministry and people who are for ADR, they would serve as the champions and they would give you the systems and you bring those systems in working, and that's how things just start moving. But for sustainability, again, the problem is if things are personality centric, once your champion judges, champion ministers, and champions are gone, then if there is no buy-in in the system, like what happened in Punjab, once the champion is gone, the person who is anti-ADR is going to shut down the system.
I see. Right? Or just revert to the status quo before.
Undermine the systems or partial systems that were created. So for a sustainable system, the only sustainable way is really the bottom-up approach.
I see. Where
you have buy-in from the actual users. Now that takes time. That takes decades sometimes.
It takes educating these people, awareness raising, all of those.
That's right. So in Pakistan, the phase has started with the top-down approach. What we are seeing at the moment is the top-down approach. Implementation of the ADR Act, that's what you're seeing.
Absolutely.
But the bottom-up approach, that's why we are pushing for instance moot competitions. We are trying to introduce arbitrations. We are pushing mediation competitions in the country. We've signed a MOU in Sindh with a school to set up clinics in schools. When the children in the schools would start seeing this as something that is effective, they start resolving disputes amongst themselves. Right? There are lots of problems, bullying issues, let's say in schools. There is no cure for that. But if you have within those communities a buy-in from the teachers, from the children, when you will have community mediations, which again is something that is recognized in the world, when we will start having community mediations, which we do in a more non-institutionalized fashion.
Yeah.
So even if you look at Pakistan right now, there are disputes maybe in every house. Not everything is coming to the court.
I mean, you put two humans together, you're going to get some disputes,
You're
right?
going to have some disputes. So these disputes on various levels, there are different layers in the society that are resolving those disputes. And if those informal systems were not there, just imagine how many disputes would end up in court.
We have a breakdown of society.
Yeah.
Absolutely.
So the courts do not have the capacity to deal with the kind of or the numbers that they would see
I see.
if these informal systems were not working. But the only problem with the informal systems is if you do not have institutionalization, then you will have problems like we faced in the Jirga system. Right? If you have one person who gives the wrong decision, right, then who is going to control that the person who has been put there to make that decision between these parties says something that is ethical, says something that is lawful, right? They can say anything they want.
They can say anything, absolutely.
Right? So how do you regulate that?
Yeah.
So institutionalization, I think, is critical to prevent those kind of things from happening. At least you ensure either you have a society where you know that ethics are entrenched, people are not going to violate those boundaries, or you have systems that will ensure that these informal systems, even if you give them flexibility, nothing unlawful and nothing unethical is going to come out of that system.
Absolutely. Nudrat, you had just mentioned that you've done part of these trainings and all of these things. So I want to come to the center that you're the International Center for Appropriate Dispute Resolution and Prevention, which you're CEO of, you've established. Could you tell us a little more about the work that you're doing with that center across Pakistan, especially in the space of mediation?
Right. So I started the center. The idea was that in the rest of the world, and especially US, about 85% of the cases are resolved through some form of ADR.
I see.
15% goes to the court.
Okay, wow.
So the court is not the first recourse.
So the vast majority of cases are resolved out of court.
Out of court.
Wow.
So there is one organization with which I'm working, JAMS, Judicial Arbitration Mediation Systems. Now JAMS does about 40,000 arbitrations mediations a year. And out of these...
And this is US based?
US based.
Okay.
And that is the thing. They cover US only. Right?
I see.
So they, some of the founders of JAMS, then they created an organization called Weinstein International Foundation. I'm a senior fellow of that foundation.
Wonderful.
And I thought that for Pakistan, so far ADR has not been institutionalized. Right? So we have ad hoc arbitrations, ad hoc systems, but there has been no institutionalization. So we had the inauguration of the center, and the law minister was there, the high court judges, Supreme Court judges were there. There were no other centers in Islamabad at that time. We talked about court annexed ADR, we talked about institutionalization of ADR in Pakistan. And from that, many of the centers emerged, right, in Islamabad. So we think of ourselves more as the thought leader. And then we started pushing for changes in the laws. We've been assisting the courts as much as we can. We've been organizing these moot competitions. Then we've been trying to create that capacity at various levels. So one of the things that we did was we became a certified mediation training provider for International Mediation Institute. So that's an international certification, and
Wonderful.
We are running 40-hour trainings to build that capacity.
And your your instructors are all Pakistani. They're all.
It's a mix.
Okay.
So far what we've done is we've had instructors from abroad for all of our trainings.
I see.
Except I think one training. There's always been some instructor coming from abroad.
But is there an effort that you're making to indigenize this?
We've done, yes.
Okay.
Yes.
Okay.
So CMTP essentially is that your materials are indigenized for Pakistan.
I see.
So the problem that we were seeing was, for instance, in the West, when they would train you as a mediator, the first thing they will tell you is you go in the room and you say you have no authority and you are not going to be deciding anything.
Mm-hmm.
In Pakistan's culture, if you enter the room and you tell people, you know what, I can't do anything, I can't decide, and I have no authority.
So you enter the room and they leave. That's basically what happens.
Basically, you are telling them, the parties are going to tell you that why are you wasting our time?
Mm-hmm.
Right? If you have no authority, why are we even here? So every culture is different, right? The Western model, I think, works well for situations where you have business disputes. Most of the trainings that are being imparted, it's mostly business disputes where both of us have this mindset where we want to expand the pie.
Mm-hmm.
It's easier. Those mediations are very easy.
So there's a joint interest in that regard.
There's a joint interest.
Okay.
Right. So many of these mediations in Pakistan, which have been going on for such a long time, trying to understand that mindset, trying to bring them to the table, trying to keep them on the table. It is going to take a lot more skills than those trainings which are telling you everyone has a common interest and you just need to find that common interest. Sometimes you don't have a common interest.
Yeah, that's very true.
Right? So every country would have, what IMI then did was, they give you certified mediation training provider status for a particular jurisdiction.
I see.
But your materials need to be indigenized for that jurisdiction.
I see.
So those are the materials that we are using.
I see. Wonderful. And in terms of the institute's work or the center's work generally, you're also working with, say, university students in terms of mock trials and these things as well.
That's right. Mostly right now we are working with the mood competitions.
Okay.
So we are organizing the foreign direct investment mood competition.
Absolutely, I heard about that.
Yes, so it's the first time that our teams were able to make it to the international rounds. They didn't get the visas for DC, otherwise they had made it.
Okay, wow.
For US, they didn't get the visa.
Mm-hmm.
We are organizing mediation competitions with WIF, Weinstein International Foundation.
I see.
And now what we are doing is moving into schools. We are moving into universities. We are signing MOU with FAST University and other universities. We are now working with the courts in Islamabad High Court. The problem they had was that they did not have enough mediators. They have one judge who's acting as a mediator, but they wanted to be in a position where if referrals are made by the judges, then there should be a mediator there and then who should be able to help them with their dispute.
I see.
So on a daily basis, we are sending mediators to the court, the court center, and they are mediating these disputes. So far, in the last, I think, 2 months, we've had around 100 cases.
Wow. And this is just in Islamabad?
Just in Islamabad.
Wow.
This is the pilot project, and we've started with the most difficult ones, which is family cases.
Absolutely. And so is this the court annexed?
This is the court
I
annexed.
see. So this is... Yeah.
So we've partnered up with them to provide them the mediators, provide them whatever help they need in order to make this a success, and provide them the systems that they need. So whatever help they need from us.
No, that's wonderful to hear. We've the Singapore Convention on Mediation, it came into force in Pakistan in 2020. It's been 5-6 years now since it's been there. What does this formalization almost of the mediation process, what does that mean for Pakistan? If at all, this thing can be formalized in that sense?
So the Singapore Convention, I think, is more influenced by the New York Convention for enforcement of awards. So the concept was that if you have cross-border disputes, and let's say if there is a settlement in those disputes, If there's an arbitration award, yes, you can now go to any of the signatory countries and you can get it enforced.
Absolutely.
But what happens if you have a settlement agreement between these parties who are cross-border? And those settlement agreements, do they have any binding force? Right.
I see.
So this convention is supposed to ensure that. Right?
Very interesting.
My understanding is, so far dealing with mediations, that if you've had a real mediation where it was not a more evaluative form of mediation, someone telling you that you need to settle, maybe this is right and this is wrong, that is the evaluation done usually by judge mediators. If you have a true process where you had the parties buy in and they have come to a solution that is their own, parties do not then try to get out of that agreement.
I see.
So do we really need the Singapore Convention in that sense? Maybe yes, maybe no, time will tell, but at least people know that there is a binding force. If we are spending this time and we have a settlement agreement, it has a binding force. We can take the settlement agreement and maybe enforce it somewhere else as well.
So if I understand this correctly, this is more of a supplementing role to it, but it's actually the agreement itself, the settlement that has come out, which is the binding force between the parties, because they are the ones who have to technically enforce.
And it's of course giving recognition to mediations as well as a process.
Of course.
So far mediation has not been a primary recourse. Right? So arbitrations are much more popular. Mediations, people would think that mediation is done mostly in family cases, but that's not really true. One of our colleagues at JAMS, Edward Bruce, he has done about 7,000 mediations, commercial mediations.
That's quite the number.
Yeah.
When does he sleep?
But as I said, many of these mediations are not going to take more than 3 hours.
That's also true. Absolutely.
So it's not years that we are talking about.
We keep on hearing about the Turkish success model and things like that. Now, in one specific area, I was just looking at the statistics during my research, and in labor disputes, when they introduced this in 2018, they had a 65% settlement rate, which is unheard of when it comes to litigation, at least. But such and this was in the first year alone. So, what can Pakistan realistically expect or learn from the Turkish experience in this regard? Because again, there are differences certainly in the way our legal systems are structured, but also there are many similarities, right? Turkey, it looks, very organized, but they also have many problems as well, much like we do.
Right. So I think what we learned from Turkey is, and it's something Pakistan can learn from as well, that the system that they introduced, the first 3 years, they were able to resolve about 3 million disputes in 4 years.
3 million disputes?
3 million disputes in 4 years, and that was through the Court Annex system. But what I think is not commonly known is that this was done by 300 private mediation centers.
Wow.
Right? So who were working alongside with the courts.
I see.
Right? So for Pakistan, what I have been promoting is more of a PPP model, public-private partnership model, that the private centers, they work with the government, they work with the courts, and of course this is not something that's going to drive in a lot of money, but this is going to be critical to set up the systems. Right? So for instance, our center, in terms of the international network that we have, we've been trying to leverage that network and try to bring the best to Pakistan.
Yeah.
These private centers, of course, can do a lot for the government. They can do a lot for the courts.
As you already are with these court annex and support that you're giving there. Absolutely.
Yes. So I think many of the people, they ask me that these people who trained as a mediator are not earning a lot of money through mediations. And I keep telling them that, look, if you want to benefit from the shadow of a tree, at least help it grow. Right? So we will get there, of course. But there are many people who will first have to do that, help that tree grow.
Absolutely.
Right?
It's almost like the provision of a public good,
That's
right? That everybody can benefit from it. You can't restrict it in any way, and because you can't restrict it, you can't maybe monetize it in that sense. And I think that's one of the issues why there's resistance, maybe even in the legal community, that if we start resolving all our disputes through mediation, which is far less costly and far less resource intensive like that, it becomes an issue. We also have a problem that in the ADR rules, I think there's a stipulated amount, 35,000 rupees, right? Do you think that is a challenge to getting qualified people to become mediators or
right.
that?
So for the court and X system, I think one has to be clear that this is something that is really helping the society, right? So there is of course a schedule which has a sliding scale.
Okay.
So for instance, a small dispute, one could charge 5,000 for the mediator and 10,000 for the center, and that keeps sliding according to the value of the dispute. I think the challenge is not that. I do not see resistance in that sense. In Pakistan, I feel the time is ripe. The resistance that we are facing is not essentially coming from the lawyers as such. It's not coming from the judges. It's not coming from the parties as such. The problem and the roadblocks, of course, that is capacity. Once you have a lawyer in the room, that lawyer, if trained as a mediator, those are the most successful mediations that we had.
Okay, wow.
Right? Because now that lawyer knows that I have an additional income stream. Right?
I see.
You make the lawyers part of the system. Right? If they don't want to become mediators, train them in advocacy in mediations, right? Advocacy in arbitrations, right? So you make them part of the system. Don't make them, don't exclude them.
So in mediations, you can have lawyers representing you as well?
Yes.
Okay.
Yes.
Sorry.
And that's what happens in the rest of the world.
So this is my lack of understanding of this area, but I see.
So there are mediation lawyers. The way you write a brief for mediation is very different. How you present a party in mediations is very different.
Okay.
Right? The mindset changes. So the roadblock that we have with lawyers, I don't think it is more of a revenue issue, that once you start resolving these disputes, what I have personally seen as a lawyer, once you help your client find the best solution for that client will come back to me with multiple other disputes that they have because they know you are effective.
Absolutely.
Right? And mediation is an effective solution. So even if you're doing it outside court, that person is going to have multiple other issues that they're going to bring to you. They now trust that you are going to work in their best interest and you have efficient solutions. So for lawyers, I feel that if they had that capacity to serve either as a mediator or to serve as a mediation counsel, that's an added stream of income. For judges, if let's say you've retired from the federal, you can't be practicing in Islamabad. What is your retirement plan?
That's
Right?
true.
So you can either stay in Islamabad and be working on ADR, or you'll have to move to another city. So it makes every sense for the judges to know that this system, we can't keep ignoring this system any longer. So for the judges, again, it's an additional stream of income. And the major player, the litigant, once they have a success story, the people who have mediated their disputes, they are never going back to litigation.
Really? Wow.
Yeah. Because now they know, again, there is an efficient solution until and unless it is something that cannot be mediated, those parties will not go back to litigation.
I mean, just the upsides are so incredible in terms of time, cost, all of these things. Like, it just seems to be the logical, I wouldn't even say alternative. This should become the default setting at times to resolve these things.
That's right. So I think once we have that capacity out there, the resistance is going to reduce.
I see.
The only problem I think that we will have, one is sustainability, the lack of proper systems, and where does the money come from? Right? For the mediator, you would need to pay the mediator.
So the party is involved, or
So
is it
yes,
a fund that the government has, or something?
The government doesn't have the money.
Okay.
Right. So one of the solutions that the courts have been thinking about is have mediator judges. They are being paid by the government, and that's how the parties don't have to pay for that judge.
So is it going to be the same judges that sit in?
Not
regular-
that case, but
Okay.
yes, that would be a dedicated mediation judge.
Okay,
That's
okay,
a
okay.
model that you have in other places
I
as
see.
well, having mediation judges.
I see.
So in Islamabad High Court, they have a mediation judge.
Okay.
But the capacity issue that if you have at least 3 to 4 mediations flowing in every day and you have one mediator judge, how do you cope with that?
Yeah.
Until and unless the private sector and private centers step in and they try to create that ecosystem, how do you cope with that? Now, the money, we are not charging anything for the services we are providing. But if you want to make this a proper system, the mediators are going to work pro bono for a while maybe, but at some point
It's not sustainable.
they would
Yeah.
want some money.
Yeah.
So in systems, this is usually paid by the parties.
I see.
In the court annex systems, as I said, the model usually is that 3 hours free, 4 hours free. If you go beyond that, you need to pay.
And is it a variable rate, or is this can this be decided that this is going to take this long, and so as a mediator I can charge this much for it, or
So mostly what they have is an hourly rate.
Okay.
So they would inform the parties of their hourly rate. If it works for them, they can negotiate. But after a point, you will have to charge. And that charge, again, it's been such a huge variation where some of the mediators, once they thought that they've got some mediations, they started asking for 60 lakh rupees. And
Wow.
our own firm paid in 2 cases 40 lakh as fee in one mediation, 60 lakh in another. And one of the court annex mediator, he asked for about 1 crore for a mediation.
Wow.
Right. So there has to be some checks and balances.
Yeah, some thresholds that
Yes.
need to be absolutely. My final question, and this is really for the young lawyers and the law students who are listening to this podcast, who want to build a career in mediation. What is your recommendation to them? What is your advice to them? How do you start a career if you're a young lawyer? But now that we've heard this, you don't even have to be a lawyer, right? Anyone who wants to get into this space, what recommendation do you have for them?
For the young generation, I think this is the best time. And in the future, it would be very difficult to practice law without knowing ADR. Arbitrations, mediations, other forms of ADR.
Yeah.
I think it is no longer a choice for us, for Pakistan, to have just litigation. The system is crumbling, right? People will have to find other ways to resolve those disputes. For the students, I would urge them that they should get these trainings, different trainings. It doesn't have to be the 40-hour training. Mediation advocacy, mediations, arbitration advocacy, arbitrations, international world or Pakistan. If you would be just a lawyer who has only litigation skills, you will be a misfit. Right? So mediation competitions, they are out there, arbitration competitions are out there. And for myself, what I've learned from my own experience is, when I started my career, I went to the courts for about 3 days, I think, at best.
Okay,
The
wow.
managing partner was working on this arbitration, so he came back. He was traveling for that, and he asked me, Nudrat, you've been going to the courts, and I was quite excited. Young lawyer going to the courts, and I'm like, yes. And he's like, I don't want you going to the courts. And my first reaction was, why? And his response was that if my daughter was in the field, I wouldn't let her go to the courts.
Okay.
Second, I asked him that, what do I do? If I am not going to the courts and I'm a lawyer, what am I going to do? And he said, I want you to be working on the arbitrations that I'm working on. And at that time, he was working on a couple of ICADRP arbitrations, multiple ICC arbitrations.
Wow.
And
So these weren't small arbitrations. These were.
And I had studied arbitration in law school for 1 hour, maybe.
Wow.
Yeah. So if that.
I see.
And here I was working on ICSID arbitrations and ICC arbitrations. And I just started that journey of growth where I would think about skills that I need if I wanted to flourish in this field. I was not thinking about when am I going to get my next arbitration or where will this really go.
I see.
But I knew that I need to have those skills. And in life, I think when other opportunities came to me, I was prepared. Right? I didn't have to go back and say, you know what, I need these skills, let me work on these skills and let me then try these cases.
Yeah.
So I think the students have a major role to play. Where we are in this point of time, I think all things have aligned because the judges are on board.
Yeah.
The lawyers mostly are on board. Yes, people are fearful what this does for our revenues. Those who have experienced mediations know that it is only going to increase their revenue. And many of the people from, the young generation, they are on board because they've seen how litigation is. It's not really working out. So the students, some of the students that we trained, they went back to Punjab University, they set up these clinics and they started teaching mediation skills. They were able to push for ADR as a mandatory component in Punjab University. So these students, I think, are the people who are going to push this movement, right? And they are the ones who are going to really bring this transformative change. Because the people who've been there for a long time, some of them are comfortable with what they know, and it takes a lot of energy
of course
to really shift the tide, and that shifting of the tide, I think, is going to come from this generation that's coming.
Absolutely. No, I think there's a lot of hope that we have with the future generation, because our generation or that has certainly failed in many respects as well. Dr. Nudrat Piracha, thank you so much for joining me.
Pleasure. Thank you so much.
Thank you.
Thank you.